This is a presentation held at the Council of Europe about Gender Equality 2018. My name is Jesper Lohse. I've been chairman of the Danish Father Association for 7 years. Initially, I started up the work on a voluntary basis as a corporate social responsibility project, doing 1 day of social responsibility a week. The Danish Father Association was founded in 1977, being one of the eldest children and father organizations in the world. We have today, after 41 years of practice, 200,000 web visitors per month from 300 cities and 50 different countries. We're very proud that we have 50% men and 50% women as volunteers. We practice or have national call centers in Denmark. We have 23 counseling centers, and every parent can go on the social media for self-help and user-to-user assistance 24/7. We are funded by the Danish state by almost 0 million euros. During my work for the Danish Father Association, and I had the opportunity to make a Harvard case analysis of the Danish family system from a leadership perspective. There was 3 questions I found that was important to ask. What is the user satisfaction and expert opinion about the family system in Denmark? What can be done to increase the quality, flexibility, and equality, and to decrease time and cost in the family system? And working with, at that time, 5 different ministers, what is the recommendation for the ministers? During the analysis, I had the opportunity to discuss the issue with Dr. Amy Edmondson from the Harvard Business School. Dr. Amy Edmondson is doing analysis in Risc Management, and one example is that she has looked at children's hospitals. Why is some hospitals better in curing children? Why don't children die in some hospitals compared to other hospitals? Amy Edmondson has also analyzed mining accidents in different parts of the world. Why is teams better in getting people up from mines during accidents in some countries than other countries? Amy Edmondson has also been analyzing the NASA space program and the very complex human processes and why human mistakes happens and not happens in that system. It's all about what we call predictable surprises. During my analysis of the Danish family system compared to the Amy Edmondson studies, I followed the child. We gathered about 1,000 different children cases and followed the child during the process of the family system. That was in all kinds of situations for ordinary children, but every time they met legislation or public unit, we noticed that. And looking at the 5 different factors that mentioned before: time and cost, equality, flexibility, and quality. Out of the many cases, we took out 25 principal cases that was analyzed in more detail. That was both cases where 2 parents did not get public information about the child, to the very complex and very critical cases for violence against children by a father or by a mother. What was very obvious by doing the analysis was that there was a tremendous amount of change of hands. In the business environment, everyone knows in the 1980s that change of hands in a human process is really what is critical. Every time you change hands in a process, time increases, human mistakes increases, and knowledge get lost. It is change of hands that you need to be very critical about and analyze. What was obvious also from the children was that even in family cases in the Danish system, you had a lot of different units that the child would meet. A child in a critical case will typically meet more than 10 different public units and more than 50 different public persons. The child also would meet legislation that was based or prepared in 12 different ministries. When we asked the ministry, how are you coordinating these different legislation in different ministries? The answer was, well, we don't really do that. It was very obvious from this very simple process analysis of complex human processes in the family system that there was no way this system would work. Talking to countries in 25 to 30 different countries, people and organizations, experts, researchers, governmental leaders, it was also clear that what we found in the Danish system also was the case in many, many other countries. Trying to visualize what the different analysis and the cases were all about, we also found out that the challenges in the family system today, with a changing world, changing family life, changing work-life balance, that the challenges were found in all types of families. In Denmark, we have right now 37 registered family types. 2/3 of the children still live together in what we call traditional families, with the father and mother together. But more than 1/3 of the children today, under the age of 18, are not living together with a father and mother. They are living in all other types of family forms. And that is an increasing number. We found that 5 to 10% of the two-home families were going into the public system. And that was a too large a group of ordinary parents and ordinary children that should never be in that system. Less than 1% was actually critical cases that you would normally expect that the system should handle. There was a clear lack of three very important items in the law and practices in the family system. That was prevention, it was gender equality, and it was the quality in the system. You could say that you are having a family system that goes to 80% perfection. But what you really need in the best interest of the child and to save even time and money in the state is, of course, a system that will go to 95 or even 99% completion and success rates. That is simply not the case, and it is a predictable surprise. Looking at the family system from a risk management perspective, it was also clear that there was human rights violations, and they were not found, they were not admitted, and they were not corrected. What is important from a risk management perspective is that if you do not take the right decision from the beginning, if you start off by discriminating parents, children, then you will not be able to create a success in the best interest of the child. By taking the first wrong decision, you will go down the path that is simply a wrong way. And you will, in most of the cases, if you do not find that mistake, admit the mistake, and correct the mistake, not be able to create the success in the best interest of the child. It is very important that in this system, when a multiple line of wrong decisions are taken based on change of hands, where you lose knowledge, you increase the time, and we see human mistakes, that you are in a situation where you should consider whether you apply by the UN Torture Convention even. We do have seen many examples of parents, fathers, mothers, children with post-traumatic stress due to the process and wrong decisions made in the system. So of course there's a lot of good work in the system. There is success examples of that, and that is of course in many situations. But as mentioned before, We right now are what we feel is at a level at 80%, where we should definitely join together, go for a 95, even 99% success rates for the children and families. What I created based on the analysis and all the gathering of the information was what I called the world's first gender equality for children and fathers, with 12 themes and 348 items. The reason for mentioning fathers here is that the discrimination was happening in 3 different levels. It happens on family forms, it happens on residential status by the parents, and it happens based on gender. By taking the fathers, all 3 different aspects would be involved, and there will also be a gender equality discussion. The aim is not to only include the fathers, but to make sure that there's open and equal opportunities and quality in the family system for children and parents, that being women, men, boys and girls. In the 348 items that were selected and listed in the 12 themes, it was all types of daily, ordinary issues for the families. You could say that the problem is that you have for hundreds of years based the family law on a single parent. That's not working in today's society, where you have freedom, you have full information, women are going into the workplace, fathers are taking care of the children, so you simply need to create a family law and practices based on shared parenting. One of the themes we looked at was the biological parents and the respect of the child for both parents, where we all could see many examples of situations where the mother and child relationship were respected, but not the child's relations or to the father and mother was respected. We found 25 different items there that would violate basic human rights. We looked at public information, which today can be provided free, digitalized to both the father and mother. That does not happen in most part of the Western world societies. Public information about a child is very often sent only to one parent. In today's environment and society, that can of course be critical if a mother is working abroad and the father is suddenly in a hospital with the child needing the basic information. Then it's not good enough that the basic public information from hospitals, schools, and so on is sent to a mother living or working abroad. We look at the paternity leave, which is increasing in most part of the Western world countries today, not only in the Nordic countries. We looked at the living residence for the child, childhood financing, international parents and different cultural and law, the public children cases, family violence not against women, but against women, fathers, and children, and where we could see that the statistics is simply not correct today. We also looked, of course, at the father's responsibility, how we could create role models by securing father responsibility and interaction and comfort for the child in the father relationships. And we looked at lawyers' ethics and methods, where we could find patterns in how the lawyers are processing these cases, which is a clear sign of a system that is working or not working, because the lawyers know exactly what's going on for their clients, and they will often use the system. So it's a question about lawyers' ethics and method to analyze is the system working or not. Another theme we were looking at was the financing statistics and research. We found out that most questionnaires about families, and therefore a lot of the research and also the political reforms, was based on answers made by mothers and children. In many situations, the fathers were not even asked about their family situation. We found a direct relation between the support, the financing of mother and children, with the support, with the research, and with the political law reforms being made. Of course, we last had to ask, how can this happen in our society? In the business environment, we have a lot of discussion about men in the financing world, but why don't we ask the question about the women in the children, social, and gender equality part of the world? It is, in our studies, very much the same things happening. We last mentioned some basic principles for shared parenting family law. If we wanted to create the law today, how would the law look? You're able to download the catalog of the 348 items and 12 themes from the World Parents organization, worldparents.org. Altogether, the conclusion and the formula were analyzed and we found was very simple. You have today shared parenting research that shows that shared parenting is in the best interest of the child in all ordinary situations. You have human rights conventions that are very clear, although simple, on many of these issues we experience today. And that, combined with what I call the world's first gender equality catalog for children and fathers, clearly document that there's a governmental legal responsibility for shared parenting reforms. Ministries and ministers will simply be personally responsible if they at this stage does not do shared parenting reforms. It is very clearly human rights violations that are happening for children and parents today. So shared parenting, combined with the human rights conventions, combined with the gender equality catalog for children and fathers, or shared parenting, modern families, very clearly documents a governmental legal responsibility. You could say we are living in a shared parenting world with single parenting law. If we look at the shared parenting research, there's a number of studies today. In Sweden, as one example, all 200,000 children in the age group of 12 to 15 has been analyzed with health data. What is compared to family forms? What is very clear in the picture is that the children with the most psychosomatic symptoms, most stress, is the children that are living most with one parent or only with one parent. The children living in traditional families or equal time 50-50 with shared parenting arrangement has the lowest degree of stress. The reason for this is not about conflict, it's not about financing, but it's about social relations. The children simply get, that's what the real life shows and the research illustrates, the children simply get more love, more comfort, has more security in life, living with both the father and mother as a general rule for all children in the country. The children has experience more peaceful parents, not in conflict. That is, of course, also an important issue, but they also experience parents that has a better work-life balance and therefore more quality time and more quantitative time for the parents. The experience of better, increased relations with their grandparents and other siblings, more holidays. So, and also the identity of having a man and a woman in life is of importance for the children. Other studies shown by Linda Jensen illustrating a number of different surveys and research projects that has been gathered. And what Linda does was to go into four main conclusions. First, children that spend equal parenting time fare as well as better than those in maternal residence, especially related to the contact with the father. Secondly, the research documents that parents do not have to be exceptionally cooperative without conflict, wealthy and well-educated or mutually enthusiastic about sharing the residential parenting for the children to benefit. Third, young adults who have lived in these shared parenting arrangements is stating that it was in the best interest of them. And fourth, most industrialized countries are undergoing a shift in custody law, public information and parents' decisions, a shift toward more shared parenting, and with the research serving to inform us, we can work together to more effectively and more knowledgeably to enhance the well-being of children whose parents are no longer living together. Looking then at the UN Convention of the Child, there are 3 articles, especially for us, that has been of interest. We all know Article 3, which is stating we should all take the decisions and considerations in the best interests of the child. However, this can only apply, of course, if the UN Convention as a whole is also respected. It seems that many people have not even read Article 2 when we ask them, and Article 2 states that parties shall respect and ensure the rights set forward in the present convention to each child without the jurisdiction, without discrimination of any kind, in respect of the child or his or her parents, legal guardians, race, color, sex, language, religion, political or other opinion, national, ethnic, social origin, property, disability, birth, or other status. What is important for us in looking at this analysis is, of course, the gender, the sex, and other status such as a family form. Children and children parents cannot be discriminated. Also important is Article 7, which states that any child has the right to know and be cared for by his or her parent. Looking at the European Convention on Human Rights, we had 4 articles that we found special of interest. We had Article 6, right to a fair trial, and I think most people know that we do have a human right for a fair trial. But what is also important is that trial needs to not only be fair, but also happen within reasonable time. We did see children cases and processes that was more than 2 years ahead. That cannot be considered as reasonable time. Article 8 is about the respect that everyone has in society, a human right to respect of family life. Article 14 in the European Convention on Human Rights also states very clearly that we cannot discriminate on any grounds such as sex or other status, such as the family form. And Article 7 states that nothing in this convention may be interpreted as applying for any state, group, or person any rights to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth herein, or their limitation to a greater extent than is provided for in the convention. We are not allowed to create national family law that is not in line with the human rights conventions. What we found in the Danish Father Association was that there was happening discrimination on 3 different levels. The discrimination was on family forms where children and parents were not treated the same way by law and practices based on whether they were living together or not living together. Parents that was collaborating positively in the best interests of the child did not have the same possibilities to create the same type of situations for the child, deciding on where should the child stay, who should have the finance to children welfare benefits, and so on, in many different aspects. We also find a very clear difference in the legal and procedural process on the residential status. Parents with the residential status of the child was having much more opportunities related to the child than parents without a residential status, not in line with shared parenting in society and 50-50% parenting arrangement. And last, we of course saw a tremendous discrimination related to gender. Fathers and children are not respected in the same way in the family law practices, not only in Denmark, but in most Western world countries today. The law, the practices, is built around a mother and child relationship, but what we should do was to look at the child and the children's right and say the child has a respect, a human right to the mother and the father. We have to start up by treating the parents equal in all types of relations for the child to benefit later in life. That is a basic human right that is violated on a daily basis. We then came down to stating what is the basic principles of a new and modern shared parenting law. We listed 10 important principles that we recommend that governments and ministries, children experts consider. The first item is that the children's parents should be the biological father and mother with respect of non-biological caretaker. Every child has the right to know and be cared for by the parents, which is of course the biological father and mother. Children can receive more love from other parents, social parents, but still the starting point has to be the children's right to the biological father and mother equally. Item 2 is about public information, that public and today free and digital information about children must be sent to both parents at the same time and method. In most Western world countries today, a lot of the information of the child is simply sent to one parent. Item 3 is about children are entitled to at least 3 months of parental leave with both parents. It has a positive effect for the child in the child and parents relationship. It has a positive effect on women's right, father's right, and the family life in general. Article 4 should be that all parents should have joint custody unless otherwise decided by a court. Only in very special court decisions, it should not be a joint custody. It is simply the children's right to the father and mother. Item 5 in today's research is based on that the shared parenting arrangement is in the best interest of the child. So the children should today be registered with double residence at both parents and with a 50% parenting time as the basic assumption if the parents do not live together. Also, in item 6, children finances should be distributed 50-50% between the parents related to benefit and expenses. And item 7, if a parent moved more than 80 kilometers away, the other parent would be primary caretaker, and the moving parents should handle all transportation unless the parents otherwise agree. Item 8.6, that under these conditions that we use shared parenting as a basic assumption in family law and practices, then parents should have the freedom to make other arrangements themselves. The experts for the children is the parents. Item 9, if a parent or public authority has any concern for the child, the case should be handled by a family court, and a lawyer and/or assessor should be appointed for the child. So we have the equality as a starting point. We have the freedom for parents to make other agreements and arrangements if they find that is important and in the best interest of the child. And we have the opportunity to make court decisions if one parent or social worker is concerned about the child's well-being. And last, the family 10, the family court can, in the best interest of the child and based on documentation and gender equality, make a different decision that will be followed with reviews for the child. We don't want to just take the decisions in court and then let the child be. We want to follow the family, the child, to make sure that the child is in a right and positive development. If we have made mistake, we want to admit them, we want to find them, we want to change them. What we have done in Denmark at this stage is that we have made family reforms. In April 2019, a very big reform started. But initially in 2015, we made a harassment package and sent a political signature to the families. We no longer would see children that were not being delivered to the other parent. We did no longer want to see families fighting about children. The harassment package in 2015 had 7 different items. One of them was that it would automatically be in the next period, the next week, that the father and children typically would see each other if the mother would not hand over the child to the father. Shared parenting is in the best interest of the child. It was no longer possible for typically the mother or parent to just say, well, we're on holiday, so now you cannot have parenting time. The package is fully respecting that we have critical cases, but it's a very few cases in total for the children. But in that cases, of course, another decision should be made and could be made. But as a general rule, as a basic assumption, it is in the best interest of the child to have shared parenting, to have a contact with both parents. Also, in many conflict cases, that will calm the situation down, looking at all the children together. What we are doing in 2019 is a very big reform, changing the structure, the culture, and the quality in the family system. The state administration are being closed, so we get a more simple system with less change of hands. We're creating a new family court and a family courthouse. All families and children going into the public system having family situations will be screened by professional children workers. The children and families will be labeled as a green, yellow, or red case. If it's a critical case, it will go in a fast track directly to the family court, where children experts, together with judges that has been educated in children cases and make best practices, will try to solve the case as best as possible. It's a very few cases going on the fast track as a general picture for all children. However, these are of course important to handle and important to handle in the right way. In the red cases, you could be in a situation where one parent should not have custody. In the yellow group, you find mediation. That's where parents are not agreeing on everything. It can be small issues or big issues, but we're trying to go in and help the family and focus on the best interest of the child with collaboration between the parents. There will be a special children unit, so every child going into the yellow or red group will have a specialized person that follows the child all through the process. This is still a very few cases in total of all children in Denmark going into these cases. However, it is of course important that if we can solve this by talking to the parents, by mediation, we should do that. In the green group, which is definitely the largest group, most of the parents would enter that group. They will be on a class, digitalized course, information about how can we live with our child in shared parenting and not living together physically. It will be an administrative registration of the family. So what we're trying to do now is in what we call Step B. Step C was a harassment park in 2015. Step B is the structure and cultural and quality change in 2019, is to create a system where we have focused on the quality in those cases where the children needs our support from society. Of course, that's a very important aspect of going into this new shared parenting world and society, where we, within the next couple of years, will see increased gender equality and a better work-life balance between men and women. There's no doubt that we need to handle the law, the family law that is based on single parenting currently as a basic assumption in most part of the law, and we need to create a modern law that is based on shared parenting and the children's right to their father and their mother equally. To do so, it's very important that we now create the quality in the system with a new family court and a new family courthouse. Also from the Council of Europe, we in 2015 took part in the resolution made by the Council of Europe related to gender equality and to improve children and father relations. The Council of Europe established a number of items that should be included and modernized in most part of the Western world countries' family law. We need to ensure that parents have equal rights and receive the same information. We need to remove any differences based on marital status between the parents. We need to introduce into their laws the principle of shared residence. We need to respect the rights of the child to be heard in all matters that affect them. Take shared residence arrangements into account when awarding social benefits. Take all necessary steps to ensure that access rights are fully enforced. Encourage mediation. Encourage interdisciplinary training of professionals. Encourage parenting plans that enables parents to determine their children's lives themselves. And finally, introduce paid parental leave available to fathers. So to conclude, what we've seen from the Howard case analysis on the Danish family system and combining it, talking to expert researchers and leaders and parents in 25 to 30 different countries, we do see that we are right now need to take shared parenting to the next level. The shared parenting research is very clear. Shared parenting as a basic rule in society is in the best interests of the child. The human rights conventions are also very clear that we need to respect family life. We need to respect that the child has a right to know and be cared for by its biological parents, We need to take decisions that are in the best interest of the child, and we cannot allow discrimination. The shared parenting research, combined with the Human Rights Convention and combined with the world's first gender equality catalog for children and father, stating specific items, 12 themes and 348 items in the first version of the catalog, still clearly state and documents that we have a governmental legal responsibility for shared parenting reforms in most Western world countries. It is a personal responsibility by politicians, by ministries, and by ministers to make these reforms. You could say that the biggest challenge in gender equality is gender equality in Western world countries today. Thank you very much for listening.